Mr. Rabinovitz.
My Lords, at the end of yesterday I was addressing your Lordships on issue 3, which was the EU law issue, and I'd noted that the issues between the parties had rather narrowed and that there was a fair amount of common ground. And among the common ground, my Lords, was first that the ITCs did indeed have their own San Giorgio rights, this being established following Danfoss and Reemsma. Secondly, that the effect of this was that EU law required that the ITCs be given a remedy in English law that would enable them to vindicate their San Giorgio rights to repayment of the amounts unlawfully taken from them by the UK state and which the UK state has refused to repay. Thirdly, that although, as is always the case when EU law does not stipulate for the remedy to be provided, it was for each member state to decide how the ITCs should be able to vindicate their San Giorgio rights. Any such remedy should not infringe the principle of effectiveness or equivalence, and in this case it's the principle of effectiveness which is remedy, which is to say whatever remedy the UK provides, it must not make a recovery virtually impossible or successively difficult. And the fourth area of common ground, and in this context, is that EU law would, we accept, regarded as satisfactory if the remedy provided involved a scheme whereby only the taxpayer could sue the state, which is to say a direct claim against the state was barred, but that this was subject itself to the principle of effectiveness, namely that this should not make the vindication by the consumer of its rights either impossible or excessively difficult. And my Lords, in addition to this, again as I noted yesterday, it is also not disputed that there remains a material part of the amounts that were unlawfully exacted from the ITCs as a result of the UK's failure properly to implement the Sixth Directive, which continue to unjustly enrich the commissioners, and in relation to which, if the commissioners are right about either issue 1 or issue 2, this would mean that the commissioners would be able to retain forever the amounts that they've unlawfully exacted. And so, my Lords, the short issue that divides the parties in relation to this issue is whether in these circumstances the commissioners are right to say, as they do, that notwithstanding that they continue to be enriched by these unlawfully exacted amounts, they can nonetheless say that the principle of effectiveness has been entirely satisfied. And your Lordships will recall that the commissioners advance different arguments in relation to the amounts which they've exacted and refused to return in the periods between broadly 1996 and 2001, we've been calling that the dead period, and in relation to the 25s element of the hundreds. And just focusing on the grounds raised by the commissioners in relation to the amounts taken by them in the period between 1996 and 2001, dead periods, the commissioners have put forward 3 arguments as to why, despite the fact that they continue to be enriched, they say that the principle of effectiveness is entirely satisfied. And just for your Lordship's notes, they deal with this between paragraphs 49 and 64.
Thank you.
That's in the core tab 9, page 153 to 160. And we deal with this, in our case, between paragraphs 65 and 79.
Yes.
That's tab 10, page 203 and following. And as your Lordships will recall, the 3 arguments that they advance, just again, I mentioned these yesterday, but just to repeat them, they say first that the reason that the ITCs have not been able to vindicate their San Giorgio rights in relation to these amounts is because the managers have a defence of passing off, and it seems to be said that because the claims are defeated by a defence rather than the absence of a cause of action, that should make a difference to the principle of effectiveness and whether it's triggered here. And as your Lordships will recall, I addressed this yesterday and made the point that it would be somewhat arbitrary and indeed irrational for the principle of effectiveness to be triggered where you don't provide a cause of action, but for it not to be triggered where you do provide a cause of action and also provide in your law a defence, which means that that cause of action is going to be defeated. But that appears to be the position that the commissioners take. It would, if that were right, enable member states very easily to stymie the principle of effectiveness. Take La Pintada, for example, arising out of Huscht and Metallgesellschaft. You say in La Pintada, the Court of Justice says in La Pintada, you have to provide a remedy where the claim is simply for interest. The state provides a remedy, but also produces a defence to that remedy, which means the claim can't succeed. Now, respectful submission, that simply cannot accord with what the principle of effectiveness requires. The second argument, again, which I addressed yesterday, which the Commissioners advanced in
Defence only arises after 3 years.
well, the defence arises. The defence is one of passing off. Sorry, the one of change of position. That arises immediately. It only becomes a defence which will work in circumstances where the manager can't get the money back. So your Lordship's right. The second argument which the Commissioners advance in this context, and again it's one I addressed yesterday, relates to the suggestion that the real reason the ITCs have not been able to vindicate their San Giorgio rights in relation to these amounts is because of Section 80, subsection 4, which I think goes to the point my Lord Mance is making, and it is said that Section 80, subparagraph 4, is EU law compliant. And again, as your Lordships will recall, I made the point that the fact that the managers have a change of position defence and that their ability to advance this defence in turn may relate to a part of English law that is itself EU law compliant, namely the existence of a limitation period which operates only between the managers and the commissioners. It doesn't operate between the consumers and the commissioners. The fact that that is EU law compliant is, as I submitted yesterday, of no relevance whatsoever. Indeed, as your Lordships will recall, there is, I mentioned yesterday in our submission, there is no reason in authority or principle why the obstacle which defeats the end consumer's claim against the supplier must itself be something that is incompatible with EU law. And indeed, as your Lordships will recall, the example that is given both in Danfoss and Reemsma as to what might trigger a requirement to provide a direct claim against the state by reason of the principle of effectiveness is the insolvency of the taxpayer. Now, no one suggests that there is anything non-compliant as a matter of EU law with the insolvency regime. But that is what prevents the San Giorgio right being vindicated. That is EU law compliant. What matters here is that there is something that prevents the San Giorgio right being vindicated. Not whether that which prevents the San Giorgio right being vindicated is EU, or involves something which indirectly involves something which is EU law compliant. And again, my lords, your Lordships will recall, I took you to that passage in Danfoss in the Advocate General, paragraph 69, where she gives, she refers to the fact that Danfoss is not able to sue the taxing authorities and is not able to sue the taxing the taxable person, because the taxable person has paid the money on to the taxing authorities and as a result has a defence. Again, as I submitted yesterday and showed your Lordships yesterday, passing on is an EU law compliant defence. But as the Advocate General remarks at paragraph 69, those are circumstances in which the principle of effectiveness would require a direct claim against the state. So the fact that involved in the bundle of issues which gives rise to the defence is ultimately something that is not non-compliant as a matter of EU law, and our respectful submission adds nothing. What matters here is that the principle of effectiveness is not vindicated because there is a defence in English law. And that then brings us to the third of the arguments, which is advanced by the Commissioners as to why they should be able to keep these unlawfully exacted amounts and why the principle of effectiveness does not require a direct claim. And that is an argument to the effect that even if the principle of effectiveness is required so that we do have a direct claim against the Commissioners, in other words, even if the principle of effectiveness requires the disapplication of Section 80, subparagraph 7, and requires, if this didn't exist, that we have the common law claim of unjust enrichment, not blocked by Section 87, that is a cause of action which should be subject to the same limitation period as applied to the manager's claim, namely Section 80, subparagraph 4. And your Lordships will recall in this regard that what the Commissioners rely upon in this regard is the reasoning of the Mr. Justice Henderson at first instance, who comes to this conclusion. Now, this wasn't a point that the Court of Appeal dealt with at all, because as your lordships will recall, the Court of Appeal found that we had a common law claim in unjust enrichment and found that that wasn't blocked by Section 80, subparagraph 7. So the Court of Appeal never had to get into the question of whether our San Giorgio rights were vindicated, could be vindicated, and whether there was any need to disapply English law. But Mr. Justice Henderson did, because, as your lordships will recall, he did find against us on the Section 80, subparagraph 7 point. I'm going to show your lordships what Mr. Justice Henderson said, just because this seems to be the basis of my learned friend's argument. But before I do, can I just ask your lordships to note, this isn't just a forensic point, but to note that this was not an argument which was advanced by the commissioners at all before Mr. Henderson. It is relevant to a legal point I will make. If your lordships can find the relevant parts of Mr. Justice Henderson in the core bundle, page 352. So it's behind tab 12.6, begins at paragraph 141.
100,
So page 352, beginning at paragraph 141.
141, sorry.
141.
Thank you. Yep. Yes, we looked at that, yep.
I looked at that. I think my learned friend started paragraph 142.
Yep,
It's worth looking at 141
Right.
because effectively he says the doctrine of effectiveness is engaged. What does it require here? That's what he says at 141. What am I required to do in circumstances where the doctrine of effectiveness is engaged? And then, as your lordships will recall, what he does is to contemplate two possible routes to, in a sense, make the claim, the direct claim, that he considers the consumer, the ITC, should have against the commissioners, subject to the Section 80, subparagraph 4 regime. And what he does is to say, well, one way of looking at this is to disapply Section 80, subparagraph 7, but in a way that continues to ensure that Section 84 continues to apply. Or he says, and I think this is where he gets to at paragraph 144, I can apply Section 80, subparagraph 4 and the limitation period there by analogy. Now, my lords, the starting point for any analysis of what Mr. Justice Henderson has done here is the recognition, and this is common ground, that the consumers were never in Section 80 at all. And it was common ground that as a result, Section 84, which only applied to claims within Section 80, therefore didn't apply to our claim. We have 3 points as to why we respectfully submit the learned judge has gone wrong here, and why we respectfully submit that the argument made by my learned friends is also wrong. The first point is this, my lord. There is no basis in law for applying to a common law claim, which we would have, a limitation period under a statute which it is agreed does not apply to us, and indeed conflicts with a limitation period in Section 32(1)(c), which does apply to us. The point I'm making is, as your lordships know, the learned judge is accepting we should have our common law claim in unjust enrichment. The learned judge is accepting that as a matter of general law, that is subject to Section 5 and Section 32(1)(c), but he's saying, notwithstanding that, I'm going to apply to you Section 80, subparagraph 4, which, in another part of this judgment, he has accepted doesn't apply to us because we're not within the statute. So he is substituting for the limitation period which does apply to us, a limitation period which doesn't apply.
He's not. Is he really doing that? He's doing this through the medium of the European principle of effectiveness.
Indeed.
He's saying you should only have a claim. All that is required is a 3-year claim within the same 3-year period as the taxpayer would have.
Indeed, and the net effect is...
If that's all the principle of effectiveness requires, then why he's not really applying directly or extending Section 87, he's really applying the European principle.
To apply to us...
What is effective?
Well, to apply to us a limitation period different to the limitation period which would actually apply to us if he's disapplying Section 87, which is his process.
No, but why are you required, in accordance with the principle of effectiveness, to have 6 years? This is, by definition, we're talking about, aren't we, an exception, which is created by the principle of effectiveness, so it can be shaped by European law.
And shouldn't it be shaped by the principle of equivalence?
It should be shaped by the principle of equivalence.
But isn't the equivalent here the 3 years?
No, with respect, no. Can I tackle this by going through the 3 points? And if I haven't answered my Lord Mance's question by the end of it, I'll directly address that. I think I will have. We make 3 points here. The first point we make is to say that what the learned judge has done here is to proceed on the basis that the rights which the consumer has are in some way subrogated rights from the rights of the manager. In other words, because the manager had a right to proceed, which was subject to a 3-year limitation, it is right also that the rights of the consumer to vindicate their St. Giorgio right should also be subject to a 3-year limitation. And in our respectful submission, that assumes that our rights are no different to the manager's rights. But with respect, that is wrong. We know from Reemsma and Danfoss that the consumers themselves have St. Giorgio rights. Those are not the manager's rights. The manager may have whatever rights the statute gives him, but what we're talking about here are the consumer's own St. Giorgio rights. And they are not subrogated rights in the sense that they should be no greater than any rights the manager had. It is true that in a scheme that the legislature put together, they have given the manager a right and they've subjected it to 3 years. But that says nothing about the rights of the consumers and how one should deal with the St. Giorgio rights of the consumers. They are their own independent rights. They don't derive from the rights of the manager. And in our respectful submission, that's the first way in which the learned judge went wrong. He started from the wrong point. The second respect in which we respectfully submit the learned judge went wrong is in relation to what it is that the process of disapplication involves. If you decide that the principle of effectiveness requires that you disapply Section 80, subparagraph 7, then the function of the court is to disapply Section 80, subparagraph 7, and not to, at the same time, legislate as to what should be there in place of Section 80, subparagraph 7, by way of a limitation period. And your lordships will recall the point made by Lord Scott, among others, in the Fleming case. And perhaps I can just remind yourself of that, where Lord Scott said that the function of the court, where English law does not comply with EU law, is to disapply a statute, not to legislate for what should be there in place. Your lordships have Fleming, volume 3, tab 36, page 1514. It starts at 1503. The passage I wanted to show your lordship, paragraph 22 of Lord Scott. Your lordships, some of you certainly will remember my Lord Neuberger was involved as part of the constitution of the court there. You may recall Fleming. There was a failure on the part of the revenue to include transitional provisions. The question was whether it was open to the court to introduce a transitional provision for a new limitation period. And it's in that context, and all of their lordships said something similar, but the clearest indication comes from Lord Scott at page 1514, the second part of paragraph 22, where he says this: there is the constitutional point which may or may not apply to judges sitting in Italian courts. This is at C. It is the function of judges sitting in the UK courts to construe primary and secondary legislation. It is the function of judges sitting in UK courts to disapply UK legislation that is inconsistent with community law. It is not the function of judges sitting in UK courts to amend UK legislation that is inconsistent with community law. And in our respectful submission, what the learned judge was doing, and in effect what my learned friends ask your lordships to do, is to legislate by introducing...
We have to be a little careful here. I think, I'm going on memory, I think that nobody, I think, else specifically agreed with Lord Scott, did they? I mean, maybe they said the same thing, but that was one view.
That was one view. Your
You
Lordship
say
is right.
others said the same thing, but ought we look, because I think Lord Walker and I were the judge, Lord Walker dissented on one thing, but otherwise everyone agreed with him and me. Did we say this too? I'm not saying what Lord Scott said is wrong, but if it's being cited as authority, it's one view.
Your Lordship is right. Everyone puts the point slightly differently.
Yeah.
I don't think anyone agreed specifically with that part of what Lord Scott is saying. But in our respectful submission...
I mean, it's an interpretation of the European Communities Act.
Yes.
Is it in play? Shouldn't we look at that to see what we're able to do?
I mean, if you're relying on this, if you say other people said the same thing, I'm not...
No, my Lord,
I'm not
saying,
asking you to look at my judgment in particular.
Your Lordship,
But
Lord
more-
Neuberger put it slightly, I think, differently, and indeed, I think, considered whether you could come up with an alternative transitional provision.
Yeah, I have to say I don't remember saying anything about it, but if I did, I think the others agreed with me.
I'm not putting what Lord Scott said as being...
You're saying it's right in principle.
It's right in
It's
principle.
support. You're citing it in support of what.
Exactly.
Fair enough. That's perfect.
But I think, I mean, for myself, I think this is not an entirely straightforward point. What we are entitled to do when we come up against a conflict with EU law. I mean, I was going to put it to you in relation to, you see, the one thing we know is protected is the case of an insolvency, where the cases say you have a right. Now, if the revenue are correct on Section 87, then that would apparently knock out any right, even in an insolvency case. So one's got to sort of modify English law in some way to provide you with a right which you don't have. If they're also right on the Menelao point, then you can't use that either. So you've got to construct a UK right to get out, to provide what EU law says you have.
Indeed.
So there has to be a certain amount of sort of ingenuity in the English court, doesn't there, to sort of try and come up with the necessary UK solution to the European problem.
My Lord, with respect, is entirely right. If they're right in relation to Menelao, then one has to mould the common law in a way that the courts did in DMG as a result, following La Pintada and Husht. In our respectful submission, that would simply say that for the purposes of the at the expense of requirement, it doesn't matter in this particular context that we're an indirect payer. Again, in relation to Section 80, subparagraph 7, if that is something that excludes the common law claim, the extent to which your lordships have to mould English law is to say that Section 87 doesn't apply to exclude this claim.
They say we just disapply it.
You just disapply it.
To that extent.
Exactly. But what may be being suggested, it's never been suggested before, what may be being suggested by my learned friends, they're not clear about this, is that you can somehow mould Section 80 to bring us within the statute, as if we were a person who had paid the tax. Now, that's not being suggested. In my respectful submission, that can't be suggested, because that really goes against the grain of that particular legislation, which was intended to provide a remedy for the taxable person.
I mean, if you can mould it to the extent of allowing for, say, insolvency situations, the argument against you is presumably you can mould it to the extent of allowing for effectiveness, and that involves a value judgment as to what effectiveness means.
What effectiveness means is we have to have a San Giorgio remedy here. What your lordship should not be doing is creating a San Giorgio remedy, which is in a sense ineffective. Now, if there were a limitation
that
period...
begs the question. I mean, if we were to conclude that it would have been perfectly effective to give you a 3-year remedy, and that is what makes sense of the scheme, why shouldn't we say that Section 80, subsection 7 is read down to the extent necessary to give you an effective remedy, meaning a remedy consistent with the scheme, i.e. within 3 years?
Because, with respect, you'd be applying a limitation period different to the one that would be applying to our common law claim. And this is the third point I was going to make. You'd be introducing a limitation period in a way which itself offended against European law.
No, you can't have both ways. The common law position or the statutory position is that you don't have any claim. We've got to modify it to the extent necessary to make it compliant with EU law. An exercise one does in other areas in relation to concepts like proportionality. One reads things down pro tanto. So we read it down to the extent that European law requires. You don't get back into the UK Limitation Act.
With respect, it's difficult to see how you get to that point and how that does not involve this court making up a limitation period without any advance notice, without any transitional position, and in a way which offends against EU principles of certainty.
Well, a possible answer to that, I mean, obviously there are lots of permutations here, but just say the revenue are right on the Meneleo point, then the consequence of that is that as a matter of English law, your remedy lies against the taxpayer. And you would have a 6-year limitation period to pursue that remedy. Well, when you do pursue it, the taxpayer will have a defence under English law of change of position to the extent that the money was paid over to the revenue and is irrecoverable because of the 3-year limitation period imposed by Section 80. So the effect is, although you've got 6 years to bring your claim, you can only, the amount you can recover is in reality limited by the 3-year period imposed by Section 80. And then the issue arises, well, is that an effective equivalent remedy for EU purposes?
With respect, my Lord, the difficulty about that analysis is that your Lordship is talking about a claim against the manager and leaving in place a bar under Section 87. So your Lordship is assuming Section 87 against me as well.
Yes.
No, I'm not.
Well, otherwise, why can't I claim against the revenue for this?
No. Well, I'm assuming you can't claim against the revenue because Mr. Moriarty wins on the issue of indirect enrichment.
This is really your second, or the second argument you dealt with, isn't it? A moment ago.
I think it is.
So I'm seeing you as being barred from a direct claim against revenue unless there is some exceptional situation, insolvency being the one that the ECJ has mentioned. Mm-hmm. But that otherwise your claim lies against the taxpayer. The problem for you is that the taxpayer has a cast iron defence to the extent that its claim against the revenue would be barred by the limitation period applicable to that transfer. Right. But you know what's the problem? I mean, if that's the English law, then the issue under EU law is that objectionable on grounds of the principles of effectiveness and equivalence.
Indeed, but with respect, my Lord, where we get to, we only get to the point that I'm on with issue 3. Can you actually impose a 3-year limitation period? If I am right to say that Malone and friends are wrong about issue 2, namely, if your Lordship goes back to the way in which this works, we say we do not have an effect. We cannot vindicate our rights against the managers because the managers have a defence of change of position.
But you could have exercised your right for 3 years.
That is true. But if your Lordship says we could have exercised our rights,
you could exercise it for 6 years.
6 years, it's true.
I mean, if you think about it, you do have. I mean, what I'm positing is that Section 32 of the Limitation Act applies. Mm-hmm. You've got 6 years to bring your claim against the managers, but the amount you can actually recover from them will exclude the dead periods because they have a change of position defence.
Indeed, and that goes to issue 2, which is it enough to say, is it right that because they have a defence to our claim, that means that the principle of effectiveness is triggered? Would Malone and friends say, the fact is that it's a defence rather than a claim. You did have a claim which is bound to fail for those years. The principle of effectiveness is not triggered in those circumstances. We say it doesn't matter if we have a claim, we have no claim, or if there is a claim subject to defence. Either way, the principle of effectiveness is triggered, and if it is triggered, that means we have to have a direct claim against the state. Now, the point that I'm on at the moment assumes I'm right about that, and says if that is the case, is there a basis for doing what the learned judge did, which was to seek to impose on that claim against the state a limitation period equal to the limitation period which was imposed on the managers?
But if you look at the defence, couldn't it be said that from the moment you paid over the money, on any view, you had at least 3 years to claim it back?
Well, with respect, no, because we may have been able to, we may have had a claim, but it would have failed because there would have been a defence of change of position.
Not within 3 years.
Yeah.
Well, within 3 years, yes, because the manager would have paid it on to the state.
But can get it back.
Well, it wouldn't have got it back. I mean, if we're looking at the chronology, if the manager had within 3 years, let's say it was in 1991, paid on the money, or take 1996 because that's the period we're concerned with, that is 8 years before Claverhouse is even issued, the revenue would have said, we're not giving you the money back. Why would we give you the money back? English law says we're entitled to this money. What possible basis can you have for having the money back?
Well, on that basis, no limitation period should be effective at all in relation to matters you don't know about, and that's clearly not right, isn't it? It's accepted that the limitation period is valid, even though you made a mistake of law and nobody knew what the law was.
But this isn't about the limitation period. This is about saying there is a defence of change of position because I've paid the money on.
But if you accept the 3 years as an acceptable period, which I understand you do, why isn't it an acceptable period for your unjust enrichment claims?
Well, your Lordship says, I mean, in theory it is, and of course the legislature could have passed a statute saying that 3 year period is absolutely fine for our unjust enrichment claim.
But on what Lord Reid put to you, that's really what the effect of the legislation is.
With respect, that's not the effect of the legislation. We're talking about a common law claim in unjust enrichment. If we're not talking about that, then I've misunderstood.
No, that's right.
All right. We're talking about a common law claim in unjust enrichment. There is legislation. There is a statute that applies to that. It applies Section 5 and Section 32(1)(c). Now, in other words, to say that we have a period within 6 years which is suspended or extended to the extent that we don't know about the mistake.
Yeah, that's what you say, but the argument the other way is that prima facie, your claim is for recovery of unjust enrichment from the taxpayer. In practice, that means 3 years, because once you get past the 3 years, the taxpayer has a defence. You accept the 3 years as in principle defensible. Yeah. So what's the problem with that now?
Because that's not a limitation period that applies to us. I accept that if there was...
But it is in practice, because it's inherent in the unjust enrichment claim.
Yeah. Well, it's because you can only recover the enrichment in respect of which there is no defence. And there is a defence to the extent that the 3 year limitation period prevents the taxpayer getting the money back from the revenue.
In a sense, we're going around in circles. The Lordship says there is a defence. The defence is a change of position defence. That in turn depends on a limitation period not applicable to us but applicable to the manager. The issue becomes whether it is appropriate in relation to a claim that we have against the commissioners to impose the same same limitation.
Yes, that's what I put to you at the very outset.
Now, if that is the case, the question arises: what is the basis upon which you can impose, in relation to a claim that we have against the commissioners, a 3 year limitation?
Well, the other point is that you don't have an unjust. It might be said you don't have an unjust enrichment claim against the commissioners unless.
Exactly.
For some reason your claim against the taxpayer can't run.
Indeed.
And it would be more than curious if, because you are disabled from suing the taxpayer because, let's say, he's gone insolvent, that suddenly your position is better under an unjust enrichment claim.
And that is the point that the learned judge had.
Yeah, quite.
And our answer to that is that assumes, that proceeds on the basis of, in our respect for submission, 2 misconceptions. The first is that there is some reason why our rights should be subrogated to the position of the manager.
No, it's not. The whole question is whether you have rights, isn't it?
Well, there's no
we're not
question.
imposing a limitation on rights which you have.
With respect to...
You're arguing you have rights because of a principle of effectiveness, and so we're considering whether it really is ineffective if you don't have these rights.
Well, with respect, we do have rights. There's no question. It's not a question of us not having rights. We do have rights.
You have rights to effective remedy. And
We have a St. Giorgio right. The
Yes.
question is there an effective remedy? Nothing that one says about effectiveness or otherwise takes away from the fact that
you only have a San Giorgio right if the situation would otherwise not give you an effective remedy.
With respect, no. We have a St. Giorgio right. The question is, do we have an effective remedy to protect that right, to enable us to vindicate that right? It's not a question of giving us rights. We have the rights. That is what Reams and Damsfos says. The only question is, do you effectively vindicate? Is it enough for the principle of effectiveness that you impose a scheme as opposed to allowing us a direct claim? If I'm right about issues 1 and 2, then this doesn't arise because we have a direct claim to vindicate those rights. There's no question but that there are rights there. The question is, does the scheme enable us to vindicate those rights? And so that is why I say there is no proper basis upon which you should be tailoring those rights, simply because the legislature has chosen, in the context of a statute dealing with a manager's claims, to tailor those rights so as to prevent any claim after 3 years. That assumes that our rights can be no greater than and are no different to the manager's rights. But that is, with respect, not right. We have our own St. Giorgio rights. And if that is right, one then goes back to the second point, which is to ask whether the scheme is sufficient to enable us to vindicate our rights in circumstances where it is common ground, the revenue are continuing to sit on an enrichment to which they are not entitled, in circumstances where we can't get the money from the manager because the manager has a change of position defense. And if that is right, and as I say, it's common ground that we can't get the money from the manager, the next question is, as the learned judge said, okay, I accept you have a direct right against the commissioners for this money, but I'm going to impose a limitation period on that of 3 years. Yeah. And the point I'm on is, where does this limitation period come from? It comes from, in his mind, Section 80, which is the limitation period which is imposed on the manager. It conflicts with the limitation period which would otherwise be applied to our claim, which is Section 32(1)(c). And the introduction of this limitation period offends against principles relating to how one goes about the process of disapplication, which is about disapplying, not introducing legislation. And coming to my third point, my lords, it is also an attempt to introduce a limitation period on a claim inconsistent with the limitation period already in the statute, but in a way which, as I say, offends against EU law. And perhaps I can just address your lordships on why I say that is the case. Can I invite your lordships to go to the Marks and Spencer's decision? Your lordships have that at volume 2, tab 19, beginning at page 952A. And your lordships may recall the Marks and Spencer's case. It related to a long-running dispute between Marks and Spencer's and the commissioners about a particular claim. There came a point at which it looked clear that Marks and Spencer's were going to succeed in their claim. The response of the commissioners was to seek to introduce a limitation period with retrospective effect, which would preclude the Marks and Spencer's claim being made. And the Court of Justice, in effect, said you could not do that because it infringed against the principles of legal certainty. And if I can just invite your lordships to go to the relevant parts of this that deal with that point, perhaps just to show your lordship first, paragraph 21 on page 981.
Yeah.
Just to show your lordship the question at the bottom of the page, in the circumstances in which...
What does this, how does this help this case? I mean, we obviously know that retrospective legislation is, in general, inappropriate.
It's not just the question of it being retrospective. If you want to introduce a limitation period,
Yes.
you have to give notice, and there has to be transitional provision.
Right. When
If your lordship wants me to show you, I'll show you.
We went through this, obviously, in the test claimants.
Your lordship has been through it. My Lord Reed has been through it a number of times, including in FII, where a lot of time was spent on this. But in case any of your lordships don't know this principle, I think it's very well established. Your lordship see the question at the bottom of the page, paragraph 21. Is it compatible with the principle of effectiveness of the rights that a taxable person derives from Article 11A, or the principle of the protection of legitimate expectations to enforce legislation which removes with retrospective effect a right under national law to reclaim sums paid by way of VAT more than 3 years before the claim made? For present purposes, if I can invite your lordships to go next to paragraph 39 on page 987, just picking up the conclusions, if I might, because I think these are well established. If your lordships look at the last sentence of paragraph 39, in order to serve the purpose of ensuring legal certainty, limitation periods must be fixed in advance. And then at paragraphs 43 and following to 46, the court also says that the principle of the protection of legitimate expectations, this is at paragraph 46, applies so as to preclude a national legislative amendment which retroactively deprives a taxable person of the right enjoyed prior to that amendment to obtain repayment of taxes collected in breach of the provisions of the 6th directive with direct effect. Now, your lordships will have noted that this is all about legislation. But it is clear from another authority that we have in the bundles, the Zeh-Fu Fleischhandel Authority, which your lordships have behind tab 27, beginning at page 1187, that precisely the same requirements of the principle of effectiveness and legitimate expectations also apply to judicially constructed limitation periods. And if your lordships look at this case, just going to paragraph 20 on page 1195, your lordships see the questions that were directed to the court. Is the application by analogy of the limitation rule, particular limitation rule inversion, incompatible with the community law principle of legal certainty, since that's the only one we have to worry about? And if I can then invite your lordships to go over to paragraph 29 over the page, 1196. Picking it up at paragraph 29. If I can invite your lordships to read from paragraph 20, read paragraph 29 and 30, and then 32 to 35.
29, 30, and 32 to 35.
Indeed.
Right.
It all depends ultimately what you mean by sufficiently foreseeable.
Well, the only thing I could say to that, my lord, is that this wasn't, I go back to the point I made at the beginning, that this was sufficiently unforeseeable that the revenue didn't even run this point. This is a point that the judge came up with on his own. Now, in our respectful submission, if anything is needed to show your lordships that creating by analogy, which was what the court, what the learned Mr. Justice Henderson says he has done, by analogy applying Section 84 was not sufficiently foreseeable, it is that. This came, with respect, out of the blue, and your lordships will not find a case in which this is done. So in our respectful submission, my lords, not only is this not consistent with the way in which the courts way in which the jurisdiction to disapply operates, which is to say, introducing limitation periods, we would also submit that one can't, without independently breaching the principle of effectiveness, seek to introduce a limitation period in this way, which conflicts with the limitation period that ordinarily applies to common law claims of the sort that, on this basis, we would be bringing.
Yes, I see.
In the written case, my lord, and indeed in the authorities, we refer to a case called BT against HMRC. That was a decision of the Court of Appeal. I'm not going to take your lordships to it, but it is an example of a case where, again, involving the revenue, where there was legislation that was required to be disapplied. The revenue argued for the introduction. The consequence of disapplying that legislation was that the limitation period, which attached to the legislation, fell away, actually related to the bad debt provision, the point at which you could claim for bad debts. The limitation period fell away. The revenue argued for the introduction of a reasonable limitation period in place of the limitation period in the legislation, and the Court of Appeal rejected that. It was Lord Justice Reimer's judgment. Now, in a sense, it's just an illustration of the point I'm making, and I'm not sure it takes matters any further. But can I just give your lordships the reference to that? It's at Volume 3, tab 32, page 1365. The relevant paragraphs are paragraphs 85 to 90, and they begin at page 1396.
1396.
1396. So, my lords, those are the three arguments that the revenue advanced for saying why they should be able to hold on to the enrichment that they have unlawfully exacted here, and why the principle of effectiveness should not assist the ITCs in relation to the money exacted during the period 1996 to 2001. There are different arguments which are advanced by the commissioners in relation to the 25s. There are three arguments. My learned friend, I don't have addressed these at all in his written submissions. I don't say that that's because he's abandoning them. I think there were two arguments which, in effect, I think he may have made this point, two arguments which depend upon issue 4. That is to say, the issues that arise in the context of the extent of the enrichment. There was a further argument which doesn't depend on that issue. My learned friends say also that if we are right about the 25s, that would result in the commissioners losing tax revenue, and they say that there is a comment in the Advocate General's opinion in Reemsma to the effect that this shouldn't result in a tax loss to...
Just remind me what issue 4 was.
The extent of the enrichment.
Right.
What I'm going to do is to come on to that now and then come back to these points, because I think they'll be easier to comprehend if I've dealt with that first. So, issue 4, the extent of the enrichment. And just for your lordship's notes, we deal with this issue in our written case, paragraphs 9 to 19, core bundle, tab 10, pages 177 to 182. The commissioners deal with this in their second written case. That's the one at tab 11, page 220.
Thank you.
And again, for your lordship's notes, this is dealt with in the Court of Appeal judgment at paragraphs 26 to 40. I'm going to come to that in a moment. And this is an area where my learned friend succeeded in the Court of Appeal, and so this is our appeal. And the issue put shortly is whether the enrichment of the commissioners extended to the full £100 paid by the ITCs and accounted for to the commissioners by the manager, or whether, as the commissioners say, the commissioners' enrichment is limited to the notional £75 element, and that they were in fact never enriched by the £25 element. So does the enrichment relate to the full £100, or does it only relate to the £75? And your Lordship will have in mind that the reason we have this distinction between the £75 and the £25 is because of the manager claiming an input credit. And before I get into the issue which separates the parties, perhaps I can just identify for your Lordships, again, the common ground between the parties here. And I think there are 7 points of common ground. In my respectful submission, they do narrow the issues substantially. The 7 points are these. First, it is common ground that the ITCs paid what we have notionally said is £100 in respect of VAT for the investment managers' services provided by the managers. Secondly, it is common ground also that the managers accounted to the commissioners for the full £100 that they received from the ITCs in respect of the VAT charged on their services. So they paid £100, they accounted for £100. Third, it is common ground that the managers accounted for the full £100 that they had collected as VAT, and for the purposes of this litigation, we have accepted that this was done notionally as follows: in relation to the £75 element by paying this over to the commissioners, and in relation to the £25 credit by applying this against the claim for input VAT that the managers had against the commissioners. Fourth, it is not now disputed between the parties that, viewed at that point in time, and leaving to one side for the moment what happened subsequently, the commissioners were enriched by the full £100.
Yep.
In relation to the £75 element, they were enriched by this being handed over to them. In relation to the £25 element, they were enriched by this having been used to discharge the commissioner's obligation to give credit to the managers in respect of the claim for input VAT. And I would note that the commissioners have abandoned an argument which they made at first instance, that simply by virtue of the £25 element not having been physically paid to it, that couldn't count as an enrichment, which is what they were saying at first instance. Fifth, it is also common ground that English law regards...
Where is this common ground on that point?
Which point, my lord?
That they were enriched by the full £100 because...
Just be careful what your lordship... the point I made, my lord, it's not disputed that, viewed at that point in time and leaving to one side what happened subsequently, they were enriched by the £100.
Yes, I mean, that's your temporal argument.
It's the temporal argument
that you make in your case.
I'm not going to run away from...
Because at that point there would be no election, yeah.
Yes.
Indeed. Well, indeed.
Yeah, okay.
So, then fifth, it is common ground that English law regards this, that is to say, the point in time at which the payment was made or the benefit received, as being the correct point to measure the extent of the enrichment. And I say that is common ground because this is acknowledged, expressly acknowledged by the commissioners at paragraph 2.1 of their notice of objections. And I don't know whether your lordships want me to show you, your lordships, that. Perhaps I just should. Core bundle, tab 4, page 96.
And what troubles me about this is, are we talking about unjust enrichment?
Yes.
They're talking about enrichment.
We're talking about enrichment, but if you look at it in terms of a claim, if there had been a suggestion by the taxpayer that the enrichment was unjust, it wouldn't have been possible, would it, for the taxpayer to suggest it was unjust for the full £100?
But what you're saying is, well, for what it's worth, I mean, even if it's not even in their written case for us, as I understand it, but it's a fair point that on page 96 they say the date of time which enrichment is to be measured for the purpose of an unjust enrichment claim.
And the point at which you measure the value of that enrichment for the purposes of an unjust enrichment claim is the date of the receipt, the date of the transfer of value.
Well, yes, as a general proposition.
Absolutely. Again, I'm not going to run away from all of the issues. I just want to set out what is common ground.
Okay, well, we see what you say. Yeah. 6.
And just for your Lordship's note, that it reflects what Goff and Jones say at paragraph 4.34 of their 8th edition.
So where have they said, viewed at that point, HMRC were enriched by the full £100?
96.
My Lord,
for the purposes of an unjust enrichment claim. I mean, when
there
you
are two separate points here, my Lord.
they're separate points.
The two separate points are this, that it is in fact common ground. Indeed, it's undisputable, if that's a word, that if you view this
if
at
you
the
made
point,
the claim the day after it was paid, you would have had a claim if all other points were okay of £100.
exactly, because they are enriched.
That's a better way of putting it. Yeah.
Well, I don't mind, my Lord.
But you hardly would have done, because you couldn't assert at one and the same time that you were entitled to the £100 back on the basis that under EU law there was no tax payable, but at the same time.
Swallow the £25.
Swallow the £25, which on the opposite footing.
I'm about to get to that, but
Right.
what I'm trying to do is to lay down general principles here
No, but
about
it's
which there's
dangerous
common
to
ground.
take each point.
Well, with respect, my Lord, in my respectful submission, it's the only way in which one can sort out what is actually between the parties.
Let's go.
Okay. So,
Okay, we've had point 5. Up to 1 to 4 seem uncontroversial. 5's a bit more problematic. But anyway, we've got
well,
your point.
problematic, but clear from what they say at page 96.
At that stage, yes, okay.
At that stage, and that's as far as I've got it.
Okay, point 6.
Sixth, it is also common ground that on the facts of this case, the commissioners do not have and have never pleaded a change of position defence. And if you have page 96 still open, this is little 2 on that page. And then 7, my Lord, it is common ground that if a party elects not to be bound, elects to take advantage of the direct effect of European law in a way which is inconsistent with English law, what he can't do is to elect the benefit of not having an output VAT obligation on him, but to seek to still be entitled to claim input VAT credit in respect of that service. So where, as here, you're providing investment management services, and you say there's a dislocation between English law and EU law, I rely on the direct effect of EU law, so that I shouldn't have to account for output VAT on that service. What you can't do is continue to seek to claim input VAT in respect of that service. And this is a point that Malone and friends make, and there's never been a dispute about that point. You take the rough with the smooth if you're not going to
Can't have your cake and eat it, and etc. Yep.
My lords, the narrow issue that separates the parties here is this. And it's when in 2004 the managers first made first made a Section 80 claim against the commissioners on the basis that despite what English law provided, this was contrary to the 6th directive, and that the services provided by the managers to the ITCs should have been entitled to the benefit of an exemption from VAT, so that the manager should not have had to account to the commissioners for the output VAT for which he had been accounting going back many years. And when, following the decision of the Court of Justice in Claverhouse, it became clear that the manager's claim was justified, so that the commissioners were obliged to repay to the manager the amounts of VAT they had received which should not have been charged to VAT, whilst at the same time being allowed to take into account any amounts claimed for credit as input VAT. What was the effect of that claim on the status of the rights and obligations that existed as a matter of English law and with which the managers had complied in all the years prior to 2004.
Yep.
In particular, my lords, the commissioners say that the effect of the manager electing to rely on his directly effective EU law rights, to say that he should not have had to be made accountable for VAT on these services, and the effect of the reckoning which subsequently took place under Section 80, was to mean that retrospectively one should treat all rights and obligations that existed between the commissioners and the managers in the years in which the manager had accounted for VAT as if they were under English law void and of no effect, in short, as if they were extinguished and had never existed. That's what they say. In other words, we accept, if you'd stopped there, we were enriched, that because there was an obligation, but as soon as the election is made and you make a claim for Section 80, the consequence of that is to retrospectively extinguish, to treat as if they were never there at all, the rights and obligations which, as a matter of English law, plainly did exist. And on the basis of that analysis, the commissioners say that just as there never was an obligation, as a matter of English law, on the part of the manager to account for output VAT, so too there was no obligation on the part of the commissioners to give credit for input VAT, and they say it therefore follows that if there was no obligation to give credit for input VAT, then there is no obligation against which to set off the £25 element. And on that basis, they say they were never enriched. And if the logic of their argument is right, then we accept that conclusion. In other words, if it is right to say that the effect of the election is to retrospectively extinguish these rights, then we accept that there never was an obligation, and it must follow that, so far as the £25 are concerned, that was never used to be applied to the discharge of that obligation, so there is no enrichment. And that, of course, is the analysis that the Court of Appeal broadly accepted, and we respectfully submit that the Court of Appeal was wrong to do that. And then we would respectfully suggest that there are three issues that arise under this head. The first issue is this: does EU law have the effect of retrospectively extinguishing the Commissioner's obligation to give credit for the £25 in the event of an election of this sort? So is the consequence for which the Commissioners contend a consequence of EU law? Secondly, does UK law, does domestic law, and in particular Section 80 of the VAT Act, have the effect of retrospectively extinguishing the Commissioner's obligation to give credit for the £25? That's what they say happened. They say it was retrospectively extinguished. First question, well, does EU law produce that effect? Second question, does UK law produce that effect? As I say, if they're right about that, they're wrong. The third question is this: if the answer to both questions is no, which is to say neither of those laws produce this result, is there any principle of the English law of unjust enrichment which justifies a conclusion that the Commissioner's enrichment was anything other than the £100 which existed at the date of the enrichment? So let's assume that both UK law and EU law, that there is nothing in those laws which says, yes, the effect of the election is to retrospectively extinguish those rights and obligations. What other basis is there for saying you should depart from the ordinary approach of English law of testing the enrichment at the date of the transfer? And can I, before just addressing your Lordships on those 3 points, just show your Lordships how the Court of Appeal dealt with this? Your Lordships will find this at paragraphs 34 to 40 of the judgment, page 248 of the core bundle, behind 12.2.
Yep.
Picking it up, if I can just take your Lordships through this, picking up at paragraph 34, the direct effect of Article 13bd6 and the other provisions of the Sixth Directive inevitably raise the issues of the legal status of any incompatible national provisions. The ECJ has resolved this conflict by requiring the primacy of EU law to be effective through the national courts, which are required to disapply national legislation and to uphold claims for repayment of the unlawful charge. And there's a reference to Simmenthal. But it has also made clear that this process does not involve the national courts treating the incompatible domestic tax provision as a nullity, and your lordships may want to underline that, and there's a reference there to the Incogo Gay 90 case. Then carrying on, the domestic provisions therefore remain effective to govern the legal relationship between the taxpayer and HMRC until disapplied through a challenge in the national courts preceded by the taxpayer's own reliance on his EU law. In these circumstances, it is for the national courts to ensure that national law provides an effective remedy for the overpayment and for national law to provide the substantive means of achieving this. And then your lordship see the quote from Incogi 90, and if I can ask your lordships just to glance at that, not sure there's anything there that particularly assists on this. Just picking it up at paragraph 36 then. Although, therefore, Mr. Rubinovitz is strictly correct to submit that at the time of the payment of the VAT was in domestic terms due and payable, the argument is ultimately a sterile one because it chooses to ignore the necessarily subsequent process required under EU law to give effect to the provisions of the Sixth Directive. The enforcement of a taxpayer's directly enforceable rights operates in the first instance through the mechanisms provided under domestic legislation, in this case section 80 of the VAT Act. Only if those are inadequate to provide a full and effective remedy under EU law must the court step in to provide restitution through the deployment of the civil law. This means, in our view, that the focus of a claim for restitution of overpaid tax based on the principle of unjust enrichment has necessarily to recognise and respect the methodology adopted for the recovery of the charge and to assess the claim that HMRC have been unjustly enriched in the light of that process. This requires the court to decide whether there has been unjust enrichment at the end of that process and not merely at the time of the original mistaken payment. Since the managers had by common consent a directly effective right to treat the services supplied to the commissioners as exempt.
Can I just interrupt just to ask, is that an accurate way of putting it? Whether services are exempt or not is a matter of law, isn't it? I mean, they can't elect it couldn't elect to treat the services as being taxable if under the directive they're exempt.
No, with respect, that's an entirely correct point. Right. And that's the point that I need to address your lordship on.
Because it's a sort of one-way game.
The taxpayer has an election, and with respect, this is the confusion that has seeped. The other side accept this, but they don't follow the consequences of this. The taxpayer, just take a step back. In a case like this, where you have UK law, which says this is a taxable service, and that is not compliant with EU law says that should be an exempt service.
It says it is.
Well, it is as a matter of EU law.
I think it is member states shall exempt.
The position, the way in which EU law works, and I'll show you a case or two on this, is to say, when it's discovered plainly, what the responsibility of the UK government is to get their act in order and to pass legislation which brings the legislation here into line with EU law. But there is a period before which, when they haven't done it, and indeed it's a retrospective period. So the manager discovers, the taxpayer discovers that there's a dislocation between EU law, under which he should not have to account for that, and English law, which, as a matter of English law, obliges him to pay that. What EU law does is to give the manager an election, the taxpayer an election.
Yep.
The taxpayer can choose to say, notwithstanding what EU law is, I elect to continue to comply with English law.
I see.
But he doesn't need to do that. And indeed, this was, I'm going to show you, your lordships, a business brief which the Revenue put out, which actually in this case said to the managers, you can carry on paying tax, you can carry on accounting for tax, because that is English law. So, since the managers had by common consent a directly effective right to treat services supplied to the claimants as exempt and were entitled to enforce that right retrospectively through the medium of Section 80, it must follow that the making of those claims operated as an election to treat those suppliers as an exempt and the waiver of the right to deduct input tax. And again, the waiver of the right is if you want to not be obliged to account for output VAT, you can't take the benefit of the input VAT. And again, we accept that. Although Section 80 sub 4 prevented recovery of the tax beyond the 3-year time limit, the claims for the dead period do not on that account justify any different treatment. The managers are to be placed into the position which they would have been in had the domestic legislation properly implemented the provisions of the 6th Directive. This would have been that no output tax was payable in any accounting periods in question, but that no recovery could be made in respect of the £25 input tax. The reversal of the tax position created by the VAT Act 1994 has to be carried out on a global basis. Once the legality of the domestic tax treatment is challenged, it has to be treated as disapplied in respect of each of the accounting periods in which it was operated. This means that even in respect of the dead period for which no direct recovery can be made, using the machinery of Section 80, the amount of overcharged tax levied on the managers is never more than £75. They must, as Lord Justice Lewison has said, take the rough with the smooth, and he refers to Birmingham Hippodrome. Consistently with this, HMRC had no obligation to allow deduction of input tax for the dead period, and the claimants have no better right than the managers to the recovery of the £25. Although the claim in restitution is not a Section 80 claim, it proceeds on the premise that tax paid was never due and that HMRC was enriched to the extent of the full amount paid. The judge was wrong in our view to regard the £25 retained by the managers as representing the discharge of any still subsisting obligation to refund that amount on the part of HMRC, and except on that premise they cannot have been enriched by more than £75 for any of the accounting periods in question. Any domestic claim in restitution for the £25 therefore lies against the manager alone. So one sees the analysis is, as a result of the election, once you make the election, that has the effect of retrospectively extinguishing.
Retrospectively extinguishing what?
The fact that at the time you paid, there was an obligation to pay. And at the time
but there wasn't an obligation to repay. I mean, you ask questions whether EU law or UK law retrospectively extinguishes HMRC's obligation to account for the £25, by which I assume you mean to repay it. But there wasn't any obligation to repay it.
I don't mean repay it.
All right, well, to account. They didn't owe anyone a duty to account for it because it was theirs.
With respect to your Lordship,
on the premise on which it was paid.
I may have misspoken, but the point was never about the obligation of HMRC to repay, or indeed the HMRC to account. The point that I was making is, at the time of these payments, if you go back to 1996...
When you say, does something retrospectively extinguish HMRC's obligation to account, I assume you meant account to someone.
Yeah.
But the problem about that is that they didn't have any obligation to account in the sense of repaying anything to anyone at that stage. They only had an obligation to accept that under the mistaken view which people had at that stage of the law, this sum was, they had received this sum. But the whole premise of your claim, and indeed of the manager's subsequent claim, is that that was all wrong and you can undo it, and the thing must be viewed the opposite way around. As soon as you view it the opposite way around, you realise that the HMRC aren't entitled, never received the £25 at all. And the people who benefited surely are the managers.
Well, I think we may have been at cross purposes. The point I had made, my lord, is that...
Be very patient.
Well, the point I had made is this, that if you view it at the time, and I'm not going to run away from the consequences of the election, all I'm saying is we need to view that logically and systematically. If you view what happened at the time, when English law, before anyone made an election at all, at that time, it's accepted that the manager had an obligation to account for output VAT, and the manager had an entitlement to claim input VAT, viewed at that time.
Yes.
Okay. And because the manager had an entitlement to claim input VAT, corresponding to that was that there was an obligation at that time on HMRC to allow a credit for input VAT, yes. And therefore there was, in a sense, a debt which the commissioners owed to the manager in respect of the £25, viewed at that time. All right, so when the payment was made, as a matter of fact, when the payment was made, if you view it at that time, there was an obligation to account for the £75, and the commissioners had an obligation in respect of the £25 to give them credit for the £25, or if you like, pay it the other way. And of the £100 that the ITCs provided to the manager, £25 of that was used to discharge a debt which at that time, viewed at that time, was owed by the commissioners to the managers.
Yeah.
And that is why, if you view it at the time, and I'm not going to run away from what happened subsequently, but if you view it at the time, there was an enrichment because the money was used to discharge a debt.
Yeah.
Now the reason I talk about retrospective extinguishing is because the point about which the parties are differ is that is the position, everyone accepts that position, until the point in time at which the manager elects, as he's entitled to. He didn't have to elect. If the manager had chosen to continue to be bound, then what I've said about the position at that time would have remained the position. There would still have been, as regards the manager.
But why are you entitled retrospectively to reverse the position? I mean, you complain about
Because there's
retrospectivity. Your whole claim is based on retrospectivity.
Well, with respect, it's not a question of retrospectivity at all. I'm entitled to claim amounts which I should not have paid because EU law says if I've had to pay amounts which I should not have paid, I can recover them back. But that's not the issue here. The issue is whether, because I make a claim on the basis that I should not have had to pay that, what that does is to retrospectively extinguish obligations which did at that time exist under English law. That's the point about which the parties are in dispute. And I say, if you look at EU law doesn't say that's what you have to do. There has to be an accounting, there has to be a reckoning to make sure we get back what we should not have paid.
I still don't understand. You're saying that at the time everything was in order, and so presumably there was an obligation to pay this to HMRC, and they had an obligation to treat the £25 as having been paid to them. But you can retrospectively reverse one aspect of that by getting back money, but you don't retrospectively give them any credit. That's the problem I'm having.
No, with respect, I'm not saying that at all. I'm saying at the time there was an obligation to account for VAT, and at the time there was a corresponding obligation of HMRC to give credit, but there should not have been that obligation. And because there should not have been that obligation, because English law did not match EU law, Section 80 provides a mechanism whereby there has to be a reckoning where the commissioners have to pay back that which they extracted, which they should not have extracted, and credit has to be given for what the manager has taken credit for, which he should not have taken credit for. But the fact that there is to be this reckoning doesn't carry with it that you have to treat that which was the position, as opposed to that which should have been the position, as if it didn't exist.
I wonder if that would, if your submission creates a mismatch between the nature of the recovery depending on who the ITC makes the claim against. If the ITC, assume there's no problem with time limit, if the ITCs within 3 years were to make the claim against the managers in unjust enrichment, the managers would apply to the revenue for the reimbursement of the £75. Would the managers have any change of position defence in respect of the £25 for which they'd claimed credit against the revenue? I think the answer is no, because there was no disenrichment. There was, in fact, a benefit. So if the claim goes through goes via the managers, then what happens is the revenue pays £75 and the managers pay £25. Why is the situation different if the claim goes direct to the revenue?
With respect, what would happen in the example your Lordship gives is that if we had made a claim, what should have happened is that the revenue should have given the managers £100 to give to us, and the revenue should have said to the managers, you owe us £25 because you, the manager, have benefited from £25 input credit as a result of incurring a VAT chargeable expenditure for which you've claimed credit which you shouldn't have. You give us that £25, but the £100 for which you accounted to us, which came from the ITCs, should go to the ITCs. What you would land up with then is that we would have got back the £100 that we had paid. The revenue would have got back a £25 credit that the manager would have taken, which on this hypothesis they shouldn't have been able to keep. If the manager still has that £25, then the manager would have been enriched at the expense of the revenue, but they wouldn't have been enriched at our expense.
Why should the revenue look through the manager? Why shouldn't the revenue simply say, you set off, we set off, here's £75?
Because the consequence of that is that we land up £25 worse.
Well, I know,
But in a sense, your lordship says, why shouldn't they do that?
why shouldn't they just say it's an accounting matter between us and the taxpayer?
Well,
You don't end up £25 worse off. You paid the taxpayers. Why aren't they the people one would expect you to look at?
we pay taxpayers, we pay the taxpayer who accounts to the revenue for the full amount of the £100. Okay. They don't pay the full amount, but they account them for.
Why aren't they unjustly enriched us against you? Why shouldn't they pay you the £25 and the revenue pay them the 75, which they then account to you for?
Because in relation to the £25 that they're sitting on, that is an enrichment at the expense of the revenue, because as against, if your lordships look at how that has arisen as a result of them claiming a credit from the revenue which they shouldn't have claimed. So if you go back and say, well, if we want to put everyone in the position they should be in here, the ITC should have their 100 because they've been unduly charged £100 of tax. You, the manager, have taken a credit on £25 which you shouldn't have. You should give us back the £25.
But if it's an exempt service, the revenue isn't entitled to £25. There is no output tax. You've simply charged £25 from your customer, which shouldn't have been charged. The revenue have no claim to that £25 on a proper understanding of the law.
The revenue weren't entitled to £100 and the manager wasn't entitled to £25. So the revenue weren't entitled to, in the end, £75, but of that, if you break down how that £75, again, it depends where one starts from. The starting point is there's £100 that they've taken, which is ours. It's been accounted for. The full £100 is accounted for by the taxpayer to the revenue. So that undoubtedly the revenue has benefited from our £100. The manager has benefited by £25, which it shouldn't have benefited from on this analysis. But if you are going to...
How can... Yeah, all right, go on here.
If you are going to restore the parties, then the way it should work is that we get the 100, the manager shouldn't be able to keep his 25, but he's being enriched by that 25 at the expense of the commissioners, because there never was, on this hypothesis, an obligation that the commissioners owed to him. So he is holding on to £25, which is rightfully the commissioners.
The reality is,
Yes, so they haven't received it.
He's holding on to the £25. The commissioners have already received the £25 from the supplier of the manager. All that the manager is paying is the residual £75 to make up the £100. It is the manager that is sitting on the £25. Yeah. And it seems to me that the weakness in your position is that if you go indirectly through the manager, you get one result. But in your submission, if you go directly against the revenue, you get another.
Which suggests that the unjust enrichment claim is very much a last-ditch thing to protect you in insolvency type, or part of the scheme is that you should have the claim, your primary claim is against the managers, and your unjust enrichment claim is simply there to protect you if the managers get insolvent.
Is your lordship on the EU law point now?
Well, really, on the whole thing, I think that to see these issues as completely self-contained may be a mistake. It could be said that if your analysis is right on the fourth issue, it may slightly undermine your argument that there is a simple unjust enrichment case here rather than saying primarily your claim is against the taxpayer, against the managers, and only if they go bust or something like that is there a direct claim, but the direct claim has to be fashioned so that you're not better off than if your claim was against the managers.
But my lord, if I'm right about issue 1, then we never have to look at this through the prism of EU law. If I'm right about issue 1, that as a matter of English law, I have an unjust enrichment claim because...
Oh yes, if you're right on issue 1.
And if I'm right about issue 2...
But I'm saying that issue 4 could be said to cast some light on issue 1. That's all.
I'm not sure.
The idea is that the scheme of the whole VAT legislation when one sees issue in the context of issue 1 is that you don't have, because of the way the VAT legislation works in this country, and that's as far as we have to look, is such that prima facie you don't have an unjust enrichment claim. Your claim is against the managers who then visit on to the revenue. The only unjust enrichment claim you have is if you can't claim against the managers because they're insolvent, for example, as Lord Reed put to you, in which case your claim against the revenue can't put you in a better position than you would have been against the managers, because it's merely a filling in a gap right, not a right in its own basis. And whether or not there is sufficient connection as a matter of theory for issue 1 isn't the point. It doesn't work in relation to the way the VAT legislation works. It's not terribly well put, but that's the flavour of it. And issue 4 supports the argument that in the context of VAT legislation, you're wrong on issue 1. Your right only exists if the managers are bust or unavailable to be sued.
That would suggest that English law and the English law relating to the cause of action of unjust enrichment should depend on EU law.
No, it's in the context of a statutory claim under the Value Added Tax Act. Connected with and one has to look at one can't just look at it as a claim. It's got to be seen in its context.
Well, I made my submission.
Just as the common law right of unjust enrichment can't be used to leapfrog contractual rights.
Leapfrog point.
I would suggest that it can't be used to leapfrog a statutory scheme.
Yes, Lord Hodge is right. It's
This is the point that my learned friend appeared to have abandoned.
Well, we have
Statutory.
not.
So I don't know whether I have to address that. That presupposes that a statute which does not prevent us should nonetheless, does not prevent us bringing a claim because we're outside the statute, should in some way be taken into account in the common law as a factor to be looked at in the context of should you regard this as being at the expense of the claimant?
Well, in the end, the common law, you can't just say, is there a claim for unjust enrichment on facts? Well, the obvious question is, if one set out the facts in this case, and without reference to any statutory provision, one would say, well, what is VAT? What does the statute say? How does it work? And you can't just judge an unjust enrichment claim without seeing the statutory and other legal context in which it's made.
Well, I accept that. Indeed, my submissions were made in part looking at how that worked. But what I don't accept is that because there's a statute giving the managers a right, that should in some way affect my claim at common law, if it would otherwise exist.
Yes, I see.
I'm still on issue 4, I think.
Yes, I'm sorry.
And I hope that what I am trying to address is clear, which is that if you get to the point of if one is in the position of saying, viewed at the time, there were these obligations, is there anything in EU law which says once you make the election, the consequence of that election is to retrospectively extinguish those rights which were viewed at the time?
I mean, viewed at the time, nobody thought there was a mistake. Nobody thought anyone had a claim. If you're prepared to accept that position, you have no claim now. So we can't just view it at the time. You're asking us to view it in the light of a known mistake. As soon as you accept the mistake, you accept that the revenue were wrongly credited £100 and wrongly debited £25. In other words, that their unjust enrichment was £75, not £100. Isn't that the problem?
With respect, that's the issue I have to address.
Yeah, but you can't have your cake and eat it. You can't say we must look at it at the time of the original payments in 1996 and nobody realised there was a mistake. Because if you look at it like that, then you've got no claim. As soon as you realise that the payment should never be made, the VAT wasn't due or properly claimable, then you're asserting the mistake and you must accept both sides of the consequences, namely that there was a wrongful credit and a wrongful debit and a net benefit of £75.
Can I just tell you, can I say again how I put it? Just so that your Lordship is clear as how to address your Lordship's point. We do say that at the time there was an obligation. We say at the time there shouldn't have been an obligation.
Yeah.
It doesn't mean there wasn't an obligation, but there shouldn't have been an obligation.
Yeah.
As a consequence of EU law, what EU law requires that you do is to have a reckoning where you pay back that which shouldn't have been paid. But none of that presupposes that there was not, in fact, in place
But
an
if
obligation.
it requires you to repay that which shouldn't have been paid, you have to give credit for that which shouldn't have been
Absolutely.
debited.
I have no problem with any of that. You do have to give credit for what should not have been debited. The question is,
Who did?
well, when that happens, are you doing that because there never was an obligation? Because if there was at the time an obligation to account and an obligation at the time going the other way to take credit, the fact that there shouldn't have been doesn't mean that there wasn't. And if
It
there
comes back to
was,
Lord Newberger's point that it's very odd if you can confine the right to a credit for the wrongful debit to the relationship between the revenue and the taxpayer.
at this stage, I'm not even trying to do that. All I'm trying to do is to analyse whether a consequence of the election of the manager to rely on his directly effective rights has the effect of retrospectively extinguishing, as between the manager and the tax and the revenue. That's the only thing I'm looking at for this purpose. It affects my position because it affects the extent to which the revenue were enriched. For the reasons I've developed. I don't want to repeat what I've said, but that's the context in which one is looking at this. It's not a question of trying to take the benefit of something and not being willing to take the burden of it. I accept it.
No, I see.
The question is the consequence of my election to retrospectively extinguish the point? And I can absolutely make a claim for repayment
Understand that.
on the basis that whatever it may have been and whatever it was, it should not have been that way. That's effectively the point that I'm making.
And insofar as the revenue, as it were, become unjustly impoverished from their point,
It's the manager that they have a claim for.
A, they have a claim against the manager, and B, it is, as it were, in the broader sense, the government's problem for legislating the way they did. And insofar as it appears to produce an odd result, it arises not from the law of unjust enrichment, but from the failure of the government to implement the directive properly and the EU rule that that the manager can elect to take advantage of the wrongful legislation.
It's a problem of the dislocation.
Understand.
Yeah.
The dislocation. Understand.
Yeah. Well, can I just, because I'm running out of time, just very quickly make the points. As I said, there is nothing in EU law which would produce a different result. EU law does not say that when the manager makes the election in this way, or where you have an English law statute which is out of line with the EU law position, that is void, because that's effectively what the revenue want to say. In terms of the voidness point, your Lordship sees that referred to actually in the context of the Court of Appeal judgment at paragraph 4. Paragraph 34, I do apologise.
No, that's fine. Yes, we saw, yes.
Your Lordship sees the last sentence. It also makes clear the process does not involve the National Court treating the incompatible
Nullity.
tax provision as a nullity. And the same point was made by the House of Lords in Fleming. Your Lordships will recall in Fleming, I can take your Lordships to it, but it's paragraphs 24.
We'll make a note of it.
24 and 25.
Yep, fine.
Lord Walker makes the point that just because an English law statute is out of line with the Sixth Directive does not make it void.
No.
So we know that that isn't why. That isn't the basis for saying there is an extinguishing of rights which plainly existed at that time. The next question is, what then is the effect of an election by a taxpayer to rely on EU law rights directly effective in the face of English law legislation to different effect? And on that, can I ask your Lordships to take up a case called Becker, which we have in the authorities' bundles? That's at volume 2, tab 13.
Thank you.
Page?
Oh
I apologise. Page 705A, I think it is.
705A. Thank you.
That's where it begins. At page 705B, one has the head note, and if I can just take your Lordships through the head note quickly.
Yep.
It would be incompatible with the binding effect which Article 189 of the EC Treaty ascribes to directives to exclude in principle the possibility of the obligation imposed by it being relied upon by persons concerned, particularly in cases where the community authorities have, by means of a directive, placed member states under a duty to adopt a certain course of action. The effectiveness of such a measure would be diminished, if persons were prevented from relying upon it in proceedings before a court, and national courts were prevented from taking it into consideration as an element of community law. Consequently, a member state which has not adopted the implementing measures required by the directive within the prescribed period may not plead, as against individuals, its own failure to perform the obligations which the directive entails. Thus, wherever the provisions of a directive appear, as far as their subject matter is concerned, to be unconditional and sufficiently precise, those provisions may, in the absence of implementing measures adopted within the prescribed period, be relied upon as against a national provision which is incompatible with the directive, or insofar as the provisions define rights which individuals are able to assert against the state. And one finds this dealt with in more detail from paragraphs 17 to 25 at page 721 to 722.
Yep.
And without reading through it now, your lordships may want to mark that.
Yes. Thank you.
The effect of this, my lords, is that where a member state has not adopted the implementing measures required by the directives, EU law stipulates that the member state may not plead against individuals, which in this context obviously also includes companies and the like, its own failure to perform the obligations which the directives entail, and the effect of this, where the directives have not been implemented as it should, those provisions may, in the absence of implementing measures, be relied upon as against any national provision which is incompatible with the directives. In other words, my lords, whereas here the manager elects to assert in a claim against the UK that it at the time was entitled to rely on the direct effect of a directive to an exemption, the UK, as it says here, is not allowed to plead against the manager its own failure properly to implement the directive, which is to say that had the manager raised the point at the time, the UK could not have sought to enforce against the manager a statute that was not consistent with that directly effective right. It would in effect be stopped from doing so. So what, in fact, the way in which EU law works here is to say that where the manager makes where there is incompatible legislation, that doesn't make the English legislation void. Where a manager chooses to rely on his EU law rights, what the state can't do is to say, tough, as a matter of English law, which is where you are, English law says this is a tax you have to pay the tax. He effectively cannot rely on his own failure to implement as a way of avoiding the direct effective rights available in EU law. It works as an estoppel. But again, one finds nothing here which says that if 5 years, 10 years, in this case 15 years later, the manager says, look, I've now discovered I had directly effective rights. You were charging me for VAT you should not have been charging me for. I want my money back because I paid tax I should not have paid. That the consequence of that election and the consequence of the Becker rule, which says the state can't plead against them, English law says you're obliged to pay, is to mean that retrospectively, English law was not what it plainly was at the time. And again, the only point I'm on is there a retrospective extinguishing of law as a result of the later election of the manager? Certainly nothing in EU law says that. Again, my lords, I said that there was an election, and indeed even in this case the revenue made clear that the manager had an election.
Yes.
Without taking you to that, can I give you a reference
Yes.
to where you will find the relevant business brief?
Of course you can. Yep.
It's volume 5, tab 63,
Thank you.
at page 2650.
Thank you.
And just on this, one can test the effect of this English law not being in line with EU law in the following way. What if the manager had not elected to rely on his directly effective rights? English law would still have applied. English law would have been as it was. It would have been valid law. So it's only because of the election that the manager is making that it is suggested not only that the state can't rely on English law, But as a consequence of that election, there is a retrospective extinguishing of EU law rights. And in my respectful submission, it is useful to test it by reference to the manager who elects not to rely on EU law to see what effect one thinks the election should have on English law. So as I say, my Lord, there is nothing in EU law which would support the suggestion that there is a retrospective extinguishing. The question that then arises is whether there's anything in English law which says that the consequence of this election is to retrospectively extinguish the rights and obligations that existed under English law at the time. And of course, we accept that English law could have adopted a position where it said if the manager makes the election, the consequence of this is that all the law which applied, all those statutory law which applied, should be treated as if it never existed, because that's effectively what's being said. But English law doesn't say that at all. The relevant provisions of English law dealing with this, obviously the VAT Act. I don't understand that there is any other act that anyone is suggesting deals with this. And there is nothing at all in the VAT Act that in any way suggests a retrospective extinguishing of the law. All the VAT Act provides for is that there should be a reckoning so that the revenue has to pay back tax that it is extracted that it should not have extracted, and as a result that should not have been due, whilst obviously getting credit for that for which credit was claimed where credit shouldn't have been obtained. But there is nothing at all in the VAT Act which suggests that you can go back in time, rewrite history, and treat all these obligations as if they never existed. And if there was something somewhere which had this effect, then one might have expected the commissioners in their written case to have referred to what it was. But your lordships will find nothing at all in the case of the commissioners identifying any provision, any rule of law, any principle which is said to have this effect. All they do is to assert that the consequence of the manager electing and the consequence of the reckoning process was to produce something which was inherently retrospective. Now, beyond commenting that that's an incredibly vague thing to say, and beyond commenting that that doesn't tell you why it follows from that you should treat obligations that existed at the time as if they were void, in circumstances where EU law doesn't say they were void, the commissioners have identified nothing which suggests that there should be this extinguishing going back in time. Nor with respect to the Court of Appeal, just going back to what the Court of Appeal say at the paragraphs that I took your lordships to, and in particular paragraphs 38 and 39, nor will your lordships find anything there that identifies what it is that is supposed to have this retrospective extinguishing effect. Again, it is simply assertion based on a conception that the process necessarily involves this occurring. In my respectful submission, there is nothing in the process that has this effect. So, my lords, we say neither EU law nor English law produces this extinguishing of obligations that existed at the time. And if that is right, whilst there plainly had to be a reckoning in relation to the credit which was taken by the managers, just as there had to be a reckoning in relation to the claim for output tax VAT by the commissioners, it is wrong to say that the effect of that or the consequence of that was to say that there never was at the time of the payment an obligation on the part of the commissioners to pay the managers the £25, and if that is right, then it is wrong to say that the commissioners were never enriched by the £25. My lords, if I am right about that, then the question arises as to why, in a case like this, one should depart from the ordinary rule of English law, which is that enrichment should be considered at the time of the transfer of value. The furthest one gets for any analysis of that, in my respectful submission, is at paragraphs 36 and 37 of the Court of Appeal judgment, where effectively what the Court of Appeal say, in the context of the discussion about were HMRC enriched and to what extent as a matter of English law, is for them to refer to EU law and to say, well, because EU law looks at the position at the end of the process, where we're considering the question of the extent of the enrichment as a matter of English law, we're going to do it at the end of the process as well. And in my respectful submission, my Lord, that is incoherent. At this stage, they're looking at the English law question of the extent of the enrichment. They accept that for the purposes of the English law of unjust enrichment, you look at it at the date of transfer. But they say that because you would also have a European right to a claim, which we would only have to consider once we've considered the manager's position, that justifies departing from the ordinary rule of English law, which requires that one look at this at the date of the enrichment. And in my respectful submission, my Lord, there is no basis to depart in the context of considering the shape of the English law claim from the ordinary English law position, simply because if we needed the European law right, that would involve looking at things at the end of the process.
You want to look at enrichment at the date of the original payment. Are you content to look at the question whether there was unjust enrichment at that date?
Well, at that date there was a mistake and they received the money, so yes.
Yes. So on that basis, effectively, you're anticipating or taking into account the claim which is based on the election?
It's a mistake. We're taking into account the fact that there was a mistake. The mistake was that we didn't know there was an election.
And so both sides of the coin of the mistake come in, namely the mistake was that the revenue was wrongly debited, so lost £25 and was wrongly credited.
Indeed. But your Lordship uses the terminology was wrongly. And in my respectful submission, one has to unpack that. What does that mean? Does that mean you were debited in circumstances where there is no obligation under English law to debit you?
Well, now you're ignoring the mistake.
Well,
as soon as you were saying that, you were saying you can't have it both ways.
I'm not trying to have it both ways. I'm saying that when one asks, I'm willing to have the rough with the smooth, I'm willing to say, at that date I was mistaken. I was mistaken because there was I was paying tax in relation to which I made a mistake in not knowing that I had an election. Not that there wasn't an existing obligation under English law, but that there should not have been an existing obligation under English law in relation to which I had an election, or the manager had an election, which could avoid the application of English law. Now, my Lords, so we respectfully submit nothing in EU law, nothing in English law, no proper basis for departing from the ordinary principle of English law, which is that you test the enrichment at the date of the transfer. Now, in those circumstances, that doesn't mean that one forgets about what happens subsequently. Ordinarily, the way in which the law of unjust enrichment treats subsequent events is by asking whether there was a change of position, a relevant change of position. There's been a disenrichment. Does that count as a change of position defence? Because if it does, then plainly the revenue can have regard to that. But as I've said, the revenue do not plead, do not rely on a change of position defence. And that is why they have to argue for this retrospective extinguishing. That is why they have to argue for what, in my respectful submission, is a rather anomalous, strange application of the law, where you can go back in time in circumstances where EU law says that you shouldn't do this and treat things as void, things which actually existed at the time. EU law doesn't say you should do that. There's nothing in English law which says you should do that. What should have happened here was that they should have said, we have a defensive change of position.
They don't have to, because change of position is when some subsequent event occurs. Their basic point is they haven't been enriched at all.
Well, indeed.
Change of position is when you're enriched and then something occurs where you're de-enriched. Here they say they weren't really enriched at all.
That's their argument. The argument is we don't have to rely on a change of position because we were never enriched. My argument is to say you were enriched. What happened was a subsequent event which disenriched you. But what is beyond dispute, not beyond dispute, but what I would say the correct position is that you were initially enriched and there was a subsequent event consequent on the manager's election which caused the disenrichment. That's the issue between the parties.
And could they have relied on change of position then?
But they, It's quite difficult to say where you're dealing with a San Giorgio right, because in the context of San Giorgio rights, it appears that the only defence is a passing on defence. Certainly what Mr. Justice Henderson has held in Prudential, a case which your lordships have in the bundles. I don't think there's any authority higher than that in the English courts which says that. It also reflects Lady and Kidd in the European Court.
Which is Henderson, Mr. Justice Henderson said that where?
Prudential, your lordships have that.
Very fine.
It went to the Court of Appeal, but they didn't deal with this point. There's a rather long discussion there as to whether the revenue have a change of position defence. Tab 51. That's in volume 4. Now, my lords, I've spent my time dealing with the issue 4. I do need to come back to just say something about issue 3. That is to say, in relation to the 25s, whether the principle of effectiveness applies, so that if we haven't got the 25s, EU law says we have to get the 25s. And in relation to that, your lordships will recall that the revenue make 3 points. They say doctrine of principle of effectiveness simply doesn't need to apply here because we never got the 25s in the first place. And if they're right on issue 4, it would follow that they were right on that as well. They say, secondly, that in any event, and I think this is, I don't know if it's a secondly or the same point, if the commissioners didn't get the 25s, that is because the managers have still got the 25s, and you would have a claim against the managers for the 25s, yet another reason why the principle of effectiveness is not required. And again, if they're right about issue 4, then it must follow that they're right about that as well. And there's nothing else I can say about that. The third issue that arises in that context is that they also say, in relation to the 25s, that if we were right and we were entitled to get the 25s as well, that would create a tax loss for the commissioners. And they rely on a comment made by the Advocate General in Reemsma to say that in those circumstances, we shouldn't be given a direct claim for that amount. Now, my Lord, in relation to that point about the tax loss, your Lordships, in a sense, run out of time on this, but your Lordships will find that although the Advocate General in Reemsma, I think this is at paragraph 82 of the Advocate General's opinion. So volume 2, I wasn't going to ask you to turn it up. Volume 2, tab 22, page 1044.
Thank you.
Although the Advocate General in Reemsma does make a comment about there being a directly effective right provided this doesn't cause a tax loss to the revenue.
Paragraph.
I think it's paragraph 82, my Lord.
Thank you. Yep. Thank you. Yep. Don't worry. Yep.
Paragraph 82 and then paragraph 84.
Yes. Thank you.
What you will find is that although the Advocate General picks up something that the Commissioner said in that context, it doesn't actually form part of her conclusions.
No, I see.
And it wasn't picked up either by the court in Reemsma or by the court in Danfoss.
Understand.
And in any event, my Lords, we would respectfully submit that in the context of this claim, there is no tax loss to the Commissioners in relation to £25. They have a claim, they may have a claim against the managers in relation to the £25 because it is the manager who would have been unjustly enriched, if we're right about issue 4. Now, my Lord, subject to anything from your Lordships, and I think one correction I needed to make about what I said in relation to an amendment that was made to section 80. That was all I was proposing to say. Can I just correct something I said in relation to section 80? I think yesterday I said Section 80 was changed as a result of the University of Sussex case, your Lordship's decision. I'm told that it wasn't changed as a result of that. It was changed to ensure that the unjust enrichment defence applied to both payment traders and repayment traders was put correctly. Previously, Section 80, subparagraph 3, only applied to payment traders, whilst the European Court in Marks and Spencer's said that breached EU law. So
Because there was the right to recover under Rule 29 or something, I think.
that's what your Lordship dealt with in University of
Didn't
Sussex.
need, yeah. Thanks very much. We put quite a few questions to you this morning. I think it'd be, if anything occurs to you over the short adjournment, wouldn't encourage you to deal with it too long. You dealt very competently with our questions, but if anything occurs to you, you should have the opportunity of picking it up at 2, and if we have to sit for an extra 10 minutes at 4 o'clock, we'll do that.
Thank you.
Thank
Can I
you.
just ask you one thing? The Virgo Chancery Bar lecture, are we going to get a copy of that?
If your Lordship wants a copy of that, we actually do have them
For
available.
my own reasons, I'd be quite interested to see.
Your Lordships, we will make them available. Some of your Lordships may not want that for your reasons. We have them
And
available.
I think it might be useful just to see where he stands.
I think it's pretty clear where he stands. We'll resume again at 2 o'clock. Thank you. Court's now adjourned.